Welcome to Ethics and Misuse of Social Media in Court. I'm Rachel Kogan, Chair of the Litigation Section of the Beverly Hills Bar Association. I'm happy to introduce our speaker for today's program, Claude Ducloux. Claude E. Ducloux is a highly accomplished attorney with over 45 years of experience in Texas. He is also licensed in California and Colorado, and he's the recipient of the prestigious Gene Caven Award for lifetime contributions to continuing legal education. We were just chatting, and Claude just told me he has delivered over 800 acclaimed presentations nationwide since 2010. He really loves educating lawyers, and he has a lot of great information to share. Claude is board certified in civil trial law and civil appellate law, and he has held leadership roles in numerous bar associations, including serving as president of the Austin Bar and chair of the Texas Center for Legal Ethics. Currently, Claude is the National Director of Education, Ethics, and State Compliance for LawPay, with a career marked by awards for his writing, pro bono service, and contributions to law and the field of litigation and legal ethics. We can't wait to see what he has prepared to share with us today. And Claude, the floor is yours.
Thanks very much, Rachel. Hi, everybody. Gee, I feel like since it's Beverly Hills and I grew up out there, I should have been handled a little trophy of some sort, maybe one of Arnie Becker or something like that. Again, I've been a lawyer. I was licensed first time in 77. I was licensed here. I took the whole bar exam in 78 in California. And I've been a working lawyer. I was a prosecutor for 2.5 years, and I joined a small law firm in the 80s, a civil trial firm where we all did, things like car accident cases. We were all defense counsel. And of course, then I crossed, from the dark side to, and then was recruited by a big New York firm. And I did that for 2 years, and I really didn't enjoy being part of a firm that was in 10 different cities. So I started my own firm, Ducloux, Carnes and De La Garza, and that's the way we practiced for the next 27 years. LawPay asked me to create a program for them because I was a pretty well-known speaker, and that has been the greatest joy, the fact that I get to share this stuff and try to help lawyers across the country to be better. Now, for those of you in Beverly Hills, welcome. I grew up in Los Angeles. I grew up right off, Crenshaw Boulevard at Vernon Avenue, which was Lamert Park, and Vernon Avenue turned into Mount Vernon Drive and went up into Windsor Hills, and that's where I grew up all the way till I was a senior in high school. And we moved to Austin because my father took over the music department at the University of Texas, where he was in charge of it in Los Angeles at USC, the University of Southern California. Spent a lot of time there. But let's go back to what we're talking about. Lawyers, like the rest of the population, often make big mistakes on social media. And one of the things, of course, nowadays, if you're doing any sort of work, you need to add a social media clause to your attorney fee agreement. I have so many presentations and so many forms if you want that agreement. I hope I have sent that to you as a downloadable form. I have a packet of attorney fee agreements for every type of practice, whether it's, personal injury or estate planning or regular things, and all sorts of additional forms for various things. So anyway, we get ourselves in trouble by using social media. We want to help you avoid those situations. Could result in malpractice because you revealed something you shouldn't have in social media. Isn't it amazing how people, if you ask someone how old they are, they say, how rude of you, but then they'll post it on Facebook. Today's my 85th birthday, whatever. Ethical breaches, subject to discipline, breach of fiduciary duty by revealing things that your client told you you shouldn't have, or making fun of your own client, which happens, and you'll see a lot. So I have lots of types of cases to show you. And then, of course, you can get monetary damages by misusing it and get sanctions and things like that. So what we're going to cover today in today's session, I have lots of things to cover, and I try to keep this really upbeat for you so we talk about it. But I do want to tell you, because I have so much that we're going to cover, if you have a question for me, I get all of my CLE email across the country and in Canada and Puerto Rico at simply Claude at lawpay.com. Claude, C-L-A-U-D-E, at lawpay.com. So feel free to email me. And if you have a question and you want to get on the phone, I do that a lot with lawyers, just talk through an ethical situation where they're just in a quandary, because that's a real specialty of mine. I've probably handled, grievance complaints against 300 lawyers and law firms and guide them on how to avoid that area in the future. So first, disregarding confidentiality and posting things on social media. Then unethical information gathering, using social media as you're somebody else to get information you shouldn't have been entitled to get. Failure to assert client control and letting your client know that you're going to lose your case on social media because you're an idiot and what you're posting on social media is going to hurt our case. Danger area number 4, evidence preservation. We'll talk about a couple of cases where people say, take down your Facebook page, and in interrogatories we'll say you never had a Facebook page. Now, isn't that the stupidest thing in the entire world? Well, no, there was more stupid things that we've seen in the last year. Ethical conduct involving jurors, looking up jurors and actually contacting them. And then, of course, with the impact of what you share in your social media posts and things like that, and then reacting to online reviews or critics, and what is the proper way for you to react to online views. Now, I will say this at the beginning, because you all know this is true. If you are going to post on social media, you will only be known by your very worst post. People are trolling you for bad posts. And I just give you so many examples of that. You might have 413 beautiful, intelligent, articulate posts. But then one night about 9:30, you've had a little too much Zinfandel, and you post something that you think sounds funny, and it comes off as racist, homophobic, something like that. Guess what? That's your post for the rest of your life. You could lose your job and everything like that. So the internet is written in ink, and no matter how much you think you can get rid of it, you're wrong. It's going to be there someplace. All right. Now, why do you need this? Well, let's go through a bit of a background. Remember, the word social media wasn't even invented until 2004. In those old disciplinary rules that we used to call advertising internet-based advertising, because there was no word for social media. By the way, I just finished 6 years on the disciplinary rules committee, where we passed about 19 new rules, and I think I had a great hand in probably about 16 of those 19 rules, because I get to teach all over the country. I see, like in Texas, there's a lot better rules. Some of your rules in California are way better than the ones we have here. In fact, I used your Rule 1.8 to fix our Rule 1.8. I used another rule from the Minnesota bar to look at how to improve our disciplinary rules. Now, remember, but let's talk about social media. And it was defined as forms of electronic communication through which users create online communities, share information, ideas, etc. And as a form of communication, it's a tool, but it's not really subject to regulation. So it's the manner that you use it which may be subject to restriction or regulation or punishment. So the problem, of course, is the ease, the speed of access, and the vast reach of social media. You know, when we used to get mad in the olden days, when I was a young lawyer at a lawyer, we'd write one of these barn-burning letters and say, "You're a son of a..." And then, of course, we'd put it in our desk drawer overnight, and we'd get up the next morning and say, "Oh, well, thank God I didn't mail that." Well, now we just push send, and then you get those odd things. Claude Ducloux would like to recall that last email where he called you an idiot. Okay, well, so you have to watch out what you're doing all the time. All right, so, and it's ubiquitous. And I try to keep these up to date, you know, as of August, to YouTube, 2.3 billion monthly active users, 2.3 billion, right? 500 hours of video. Can you imagine this? Since I've been talking, over 1,000 hours of videos have been uploaded to YouTube. It's just amazing. 2.9 billion monthly active users of Facebook, 1 billion registered users of what used to be Twitter, 396.5 million monthly active users. Now, I'll bet that's gone down ever since Mr. Musk, who lives right here in Austin, Texas, has taken that over. LinkedIn, 706 million. Instagram, over 800 million active monthly users and 500 million daily active users of Instagram. Now you ask, Claude, what do you use? I use very little. I do have a Facebook page, but a minimal attention to it because frankly, I don't have time to keep, and I don't care about commenting on everything. I'd rather write a letter to the editor. And then TikTok, 1,398,000,000 monthly active users. So it is simply everywhere. I love YouTube though, because if you talk to like my kids, they're, you know, in their late 30s, early 40s, if I say, how are you going to fix your toilet? And they go, I don't know, I'll go to YouTube. And that's exactly right. Just about anything you need to fix. I had an old 2012 Mercedes that had a dead battery. And I thought, oh, I don't want to take it to the dealer. They're going to charge me $300 to tell me, oh, your battery's dead. Yeah, I already know my battery's dead. So there it was. How do you change a battery in a 2000 Mercedes, whatever it was, a C230, whatever it was. And there it is, 7-minute video on how to change my own battery. So YouTube is just wonderful. All right. Social media by the numbers. In May of 2018, Facebook and YouTube dominate 5.16 billion accounts worldwide. And 80% of all adult Americans have at least one social networking account. And 58% of us have 2 or more. 16 minutes of every hour spent online is spent on Facebook. And there are more Facebook profiles created every second than there are people born. So there are more Facebook profiles than people born, and more than 1 billion tweets are sent every 48 hours. So now, because of all this, we have this new duty of competence, and I give this around the country, and I try to put in your rule, but all of us within the comments of our rules, usually it's our rule 1.1, if we're following the general pattern of the ABA, is that we have to maintain the requisite knowledge and changes in the law and technology and all that kind of stuff. And we have a duty to do that, which means, you know, if you are going to continue practicing the law for a long time, we know this, and you're hiding from it if you say, well, I'll just get someone else to do it. No, you need to learn how to do it. You need to learn how to file your own pleadings, even though lawyers generally hate learning new stuff. You younger lawyers, God bless you. You learn stuff more easily and more quickly. And we need for you to mentor us, and we can help you with other things. But I know myself, you know, that I just don't like having to learn new stuff, especially as old as I am. And of course, we're going to have to hold you to a higher standard. Right now, for example, if you're picking juries and you haven't at least, and you had the time to Google, you know, some of the jurors, you could find out a whole lot more about them simply with a publicly available information. So now some courts have said you have a duty to, if you have time to do that, you should. In fact, there was a case in Texas where the old lawyer, even older than I am, you know, picked a man for his jury who actually ran a group that was against the insurance company that the old lawyer was representing. You know, I won't name the company. I'll just call it Never Pay Insurance, which covers most of them. At any rate, and said, but the guy is he has a never pay, anti-never pay, and you put him on the jury and you lost that case. It was a hung jury. You should have found out about that, and it was malpractice for you not to do that. See, in Missouri, affirmative duty to research juries online. In the Ninth Circuit, they said the failure to investigate social media in Kennedy versus Adam and the media recantation of a sexual abuse victim held to be inadequate. In other words, the victim said, well, you know, it didn't really happen. Just like that, remember the alleged victim came clean. She was the attacks by that, what is a lacrosse team at Duke never really happened. Well, that doesn't help anybody. That's 12 years ago. Womack says Yeoman, the dangers of not being conversant with technology. There, the plaintiff's lawyer wrongly accused the defense lawyer of hacking the plaintiff's social media account. Wrong. All the information is publicly available, and he got sanctions. Okay, what about privacy? If you haven't been following the wonderful tale of our Attorney General Ken Paxton, oh, you've missed a really bad telenovela soap opera, because we have somebody that's, wow, as our Paxton. Paxton got sued by his own personally picked assistants, right? And for whistleblowing, they reported him, his top aides reported him to the FBI. And with the protection of the Supreme Court, he never even had to sit for a deposition. He wouldn't be put under oath. So, but this was the Austin Court of Appeals, which is much more enlightened than most of the judges. And they said, no, you have a right of disclosure privacy in zones of privacy that you have a right to expect. And that would include, matters relating to marriage, procreation, contraceptions, family relationships, and child rearing and education. Well, of course, that's all being changed quickly by our courts here in Texas. So let's just go directly to danger area number 1, disregarding confidentiality. And people who love to post, you can be sure of one thing, they love to post. So here's one thing. Here's how you safely shoot someone. This out of Tennessee, this lawyer put on his a story of here's how you can shoot someone and get away with it. Attorneys advised to engage in criminal conduct and avoid arrest, violated the disciplinary rules. And following a hearing, the Tennessee Supreme Court raised his punishment to 4 years of suspension with 1 to do and 3 probated. And they said there was ample evidence to support the court's conclusion that the attorney violated the rules of professional conduct, should be subject to discipline, required lawyers to complete 9 hours of CLE focused on ethical use of social media by attorneys. They found the attorney, in fact, offered advice on how to use deadly force and concoct a false defense. Yeah, I think that's probably not what you ought to be doing. Okay, now this was out of Florida. A public defender took a picture of her client's underwear because that's how tough this is going to be, a tough trial. It needed to wear that, leopard underwear. It was written by public defender Anya Citron Stern, where she shared information for her male client's choice of underwear. Motion for mistrial was granted and the lawyer was fired. Look before you tweet. Oh, tweets, of course. Sarah, she became famous. Sarah Peterson, her research attorney with the Kansas Court of Appeals, tweeted she was watching a legal proceeding and it was against another court official, and she's tweeting to her friends, "Ooh, he's a naughty, naughty boy." And this, why is Phil Klein smiling? There's nothing to smile about. I think there was something about being from Deutschland, but something, some sort of D-bag. Anyway, so what happened to her? She had to come on the carpet and say, "I'm so sorry. I didn't think that in addition to communicating with my friends on Twitter, I was also communicating with the public at large. It is not appropriate for somebody who works for the Court of Appeals. I apologize because the comments were made on Twitter and thus public perceived as a reflection on the Kansas court." She was fired, information admonishment, which was the only thing. Now, what about another lawyer's incendiary post? Paul Trawick of South Carolina, suspended for 6 months when he writes on Facebook about the George Floyd's women's tattoos that are explicitly incendiary. Here's how much that S. Stain's life actually mattered, referring to George Floyd. Stock futures are up. Markets move higher Monday and Tuesday. And he says to anybody who doesn't agree with that, F you, you can just unfriend me. So he got a 6-month suspension, diversity education, which of course is a no-no now in the state of Texas, anger management, and comply with treatment recommended by lawyers helping lawyers. So, again, you're always going to be known by your absolutely worst client. Here is another, I would say probably poor Mr. Pishek was burned out. He was a public defender and he's texting to his friends, "Look, this stupid kid is taking the rap for his drug dealing dirtbag of an older brother because he's no snitch." And he says, another one, he said, "My client's in college, just go to show that higher education doesn't imply you have any sense." And then his third client, he goes, "He's standing there in court, stoned right in front of the judge and the probation officer and prosecutor and swearing he was clean." So here he's clearly texting something against his client's best interest. And what happened to that? He was suspended for the practice and was fired after 19 years with the public defender's office. And again, and only for his mental health, sounds like he was burned out anyway. "You shall not reveal information relating to the representation of the client that the client gives informed and the disclosure is authorized to carry the representation or the disclosure is permitted by paragraph B." All right, let's go on to danger area number 2, unethical information gathering. Ethics opinions about contacting witnesses via Facebook. We have all these, I look at so many of these because I give speeches live in Philadelphia, and I give speeches live every year in New York City, and all over the place. But the basic thing that you need, I do a whole hour on Can We Talk? That's the name of it. And it's if you're a litigator, when can you call and talk to employees of the defendant corporation without having to notify the attorney? And I'll cut you to the chase. The general answer is, if that employee that you're trying to contact of a corporation you're suing, if you're trying to hold the corporation vicariously liable by what that employee did, you must assume that the company will provide counsel to him, because if they're that high up on the food chain of the officers, you can't talk to them without notifying the other attorney. But you can if you're just trying to get facts from somebody. That's generally, now again, case law is very dynamic, could be moving. You can't face friend a witness, of course, under false pretenses. Remember, you can't make a false statement of material fact or law to a third person. Now, we know that under our fiduciary duties, which is the highest duty imposed or relationship imposed by law, that we can't lie to our clients and we can't do this. But you might think, well, I can lie to the opposing party. It's advocacy. It's just it's puffery. It's everything. We're gonna kick your ass. Well, that's not it. Here's what they mean. You can't make a deliberate misstatement about a law or fact if you know that person is relying on that. I try to use this example. Let's say you're collecting a debt, and the guy owes $5,000. So you sue him for $5,000, but you send him, he's a pro se, and you say, look, if he'll pay us $3,000, we'll settle the case. What do you say? And he thinks about it, and he calls you back in 2 weeks. Say, okay, I'll pay the $3,000. You go, oh, dang it, you only had 10 days to respond to that under law, so now that it's over 10 days, I can't settle for less than $3,300. I have to charge you 10% more, which is a lie. Now, that would be a lie. That would be agreeable because you're lying about the law to him. You can say anything you want, but you can't make a material lie that a person is relying on and believing you in making a decision. And then you can't engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Boy, that's certainly imposed a lot, isn't it? Case of false friending in May 2012, Ohio civil suit filed against an insurance defense firm, right, for impersonation to gain access to this minor's Facebook page of the minor plaintiff in a dog. So they say, hey, we want to join your Facebook. And the claims of invasion of privacy and violation of the wiretapping statute. And in June 2013, a Cleveland assistant prosecutor was posing as a fictional baby mama of a murder defendant in order to persuade the two female alibi witnesses not to testify, saying, oh, no, don't do that. Don't give it, because he's a bad person, and I'm the baby. Well, that's a lie. You didn't that. 1 year suspension from the practice of law, but it was probated because you'd never had another complaint. Disbarred for ghosting. This one is really interesting. Every year I am the course director of the State Bar's most expensive trial course. It's called Advanced Trial Strategies. It's always in February in New Orleans. And it's going to be February 13th to 14th this year again. And so everybody kind of thinks in New Orleans, oh, it's a lovely place to visit, but so backwoods, and no, it's not. They have some really good ethics opinions there. But here, this guy, Salvatore Pericone, was a assistant U.S. attorney, and he filed 2,600 comments under assumed names. And I mean, he bitched about everything, and he commented on various defendants and cases. He insulted politicians, lawyers, police officers, and other citizens. And the Supreme Court of Louisiana disbarred him, saying, you're a prosecutor working with the U.S. attorney, and that was a breach of public trust. You inflicted harm on individuals. You insulted the prosecutor's office and the legal profession as a whole. So it was a really good opinion, and I've referred to it later. Don't communicate with represented parties. We talked about that a second ago. If you know that they are represented, you can't talk to them without. Now, again, I do this longer thing about what if the client calls you, right? but he's represented by Joe Doe. And I said, well, I got to notify Mr. Doe. So you notify, said, Mr. Doe, your client wants to talk to me. Do you want to be there? Mr. Doe, most cases, you give it a good college try. If the attorney doesn't, respond, then I think you can assume he's not representing him anymore under most times. So anyway, but do your due diligence and try to make sure that you go through the attorney. And you can't use social media for that to get around it. And don't sweep Snapchat message a represented party. You can't friend request former co-employees of the plaintiff in a labor case. They're considered represented parties because they were high enough up on that food chain. And the famous Robertelli Adamo case in New Jersey, that allegedly directed the paralegal to friend request a young male plaintiff in a personal injury case, even though he was represented by counsel. They got only an admonishment because nothing happened, but it was later appealed and dismissed because the judge said, well, we really don't understand how Facebook really works. It was too novel at the time that they did that. Okay, so what is the appropriate standard? And that's what I just talked about. They recommended that New Jersey join Massachusetts, Colorado in this standard. Any attempt by an attorney or the attorney's subordinates or agents or proxies, including the client itself, to gain access to a represented party's otherwise private social media is an improper communication in violation of Rule of Professional Conduct 4.2. Furthermore, any attempt to gain access, in other words, that don't call means including going through their social media. And any attempt to gain access to the social media, whether he's represented by counsel or not, without explicitly disclosing who is making the request and the specific purpose of the request, constitutes conduct involving dishonesty, fraud, deceit, misrepresentation. Accessing and viewing public information out there is completely all right, even though they might see that you're looking at it. You put it out there, they can see it. Inappropriate friend request from a judge. This is an interesting some of these, of course, are Florida, but always the most important and crazy things happen in Florida. Judge Linda Schoonover presiding over Florida divorce case while she's the judge. And the wife and the husband are sitting, and she sends an ex-parte friend request to the litigant wife. She wants to be friends with the litigant wife. She was, attractive and everything. When the litigant declines the request and tells her lawyer, he said, the judge is sending me a friend request. The judge, the judge then retaliated, awarding most of the marital debt to the wife and ordering the wife to pay excessive alimony to the husband. Well, the result, of course, was overturned, and the judge resigned while they're investigating her and the complaints against her. Now, I always said, what would I do if that happened? My client comes to me and says, hey, Judge Scott sends me a request. I'd think I've got to have a conference with the judge and the other lawyer. I would say, Judge, may me and the other employer please prospect. My client has indicated that you have sent a friend request to her, and I don't think that we need to discuss that. And certainly Mr. Jones, the other counsel, needs to know. Anyway, so danger area 3, failure to assert client control. Having that conversation with your client saying, I will not lose your case on social media. During this case, you will not post about anything. You will tell your children, your grandchildren, your grandparents, your brothers and sisters and friends, do not post anything on social media about this case because I am not going to lose your case on social media. In Gulliver Schools versus Snee, Florida Court of Appeals, the daughter winning, they sued the school. They got an $80,000 confidential settlement. So she posts a, whoa, Mom and Papa Snee won the case against Gulliver. They're now officially paying for my vacation to Europe. Suck it. The whole settlement went out the window. The plaintiffs violated the Facebook post, violates the release confidentiality provisions. So take that seriously. If your client has a confidentiality clause, when I'm mediating a case where they've agreed to that, I actually write out for the parties what you're allowed. From this point on, you're only allowed to tell your lawyer and your accountant, as required by law, or government institution who's required to know that. Otherwise, anybody who asks you, you say, the case was resolved to the satisfaction of the parties, and that's all I can say about it. I write that out for them, so they do that. All right. West Virginia criminal defense lawyer was ordered to show cause why he shouldn't be held in front for allegedly giving his client a copy of the confidential packet containing the identity of the confidential informant. So the client's roommate then posts several photos of the packet on Facebook showing the name and address and bragging about, I'm going to expose the rat. Result of an imposition of a monetary fine. I think he should have been disbarred if he did that. Now here, this is the rapper 50 Cent, and he's going through a bankruptcy, and I love these pictures. Can you imagine the bankruptcy lawyer seeing this? Because here he is spreading out on the left things. He's spelling out the word broke in $100 packets of $100 bills, and there he is on the second and third picture. He's on a private plane with piles of money behind him. So he's ordered to come to court and say, explain to me why we're here in bankruptcy court with all that money behind you. All right. Be aware of what the prosecutor is posting as well. In People versus Armstrong, 2014, the prosecutor posted Facebook about a plot to kidnap the key prosecution witness. In Missouri versus Pope, the DA tweeted before, during, and after trial called troubling and concerning by the appellate court. There was a judge here in Texas who loved to post during trial, ooh, I think the defense is really doing a good job, and the plaintiffs, the lawyer's no slouch either. And the Commission on Judicial Conduct going, what are you doing? Oh, well, I'm not allowed to. No, you're not allowed to do that. Danger area number 4, evidence preservation and spoliation. All right, social media posts are evidence, right? 3.1, a lawyer, you may not unlawfully alter or destroy evidence and cannot direct or assist others to do that. That's rule 3.1, right? Alley Concrete versus Lester. The wrongful death case, the surviving husband was told to clean up his Facebook page and then answer sworn interrogatories that he didn't have a Facebook page. $722,000 in sanctions. And the plaintiff's counsel resigned from the practice of law and had his license suspended for 5 years by the Virginia bar, where he was also licensed. Now, spoliation, of course, is defined as the intentional, reckless, or negligent withholding, hiding, altering, fabricating, or destroying the evidence relevant to legal proceedings. So I'm going to tell you this very quick story. I think I'm one of the only lawyers I've ever known who I actually got the judge to give a spoliation instruction to the jury. I had a jury of 12, and it was a case involving damage by a speeding, what I said was a speeding locomotive, to hitting trucks across an overpass. Luckily, no one was killed. So I'm trying this case. And I know that these locomotives had at the time what they called speed tapes on it that shows 24-hour period. It was like a graph that went around for 24 hours and how fast the train was going. And I allege it was speeding. So that would prove if I was right or wrong, that speed tape would show it. So when I requested that speed tape in discovery, they said, oh, we didn't have it. It wasn't on it. And the last witness at trial was the brakeman who was in the caboose, and he said yes. He walked up, and I said, "Well, now tell me about this. You talked to the. Were you up in the cabin? And where they have those? Don't they? Is that where they put those speed tape right in the middle on a pedestal? Yeah, yeah. And did this one have it in there? Yeah. Was it working? Yeah, I think it was. Oh my God. So I got the judge to give the jury an instruction saying, if you find that a specific piece of evidence which would have been determinative of an issue was peculiarly within the control of one party and that party refused to produce it, you may assume that that piece of evidence would not support their case. So once I got that spoliation instruction, I was home free and won that case, and actually won more than I asked for because they don't like people that lie. Gatto versus United Airlines. Personal injury plaintiff deactivated his Facebook account during the midst of discovery, unbeknownst to his lawyer. Spoliation. Plaintiffs and premises liability case solicits witnesses to change their stories on Facebook, then deletes the Facebook messages. I once was in a case, a high dollar case. It was a very well-known family where the husband left the wife a voicemail on the old tape machine saying, I'm going to come over there and mess you up and no one will ever find out about it. Beep. So there was the tape. Who leaves a message like that on the tape? Patel versus Havana Bar. Plaintiff premises solicits witnesses to change their stories via Facebook. Yikes. So know what your client is up to. Can you advise your client to clean up the Facebook pages? Okay, there's a bunch of good ethics opinions, but I will boil them all down to this. That you can do this. You can say you can up your privacy settings. You can take things off your Facebook page. You know, if you claim your back is hurting, you might not want to have that picture of you doing, 5 twirly tumbles on there anymore, but you cannot pretend they didn't exist. And you can be asked about those. So you cannot destroy anything, and you can and then you can just not respond. Is cleaning up your Facebook spoliation. All the ethics opinion, this is kind of what I said it's okay to provide advice on what privacy settings to implement, as well as to counsel them on the content that they post and its potential ramifications. It's permissible to advise clients to remove or take down content as long as no spoliation. You don't destroy that content. And all evidence preservation obligations are adhered to. And of course, those of you who are much more adept at this technical stuff will tell you we have what's called, or what the engineers referred to, the Wayback Machine. And that'll show what your Facebook page or what your website looked like in 1992 if you had one. So there's always ways. That internet is written in ink. Right now, I know you're not reading this. I'm just showing you about the first page of my social media addendum that on the rules of social media, meaning you will come up, you will look at all your social media, your websites, your pros, your LinkedIn, and everything like that. We're going to turn this up, and then on the second page, you will not post anything at all about this case. You will tell everyone around you not to post. You will not respond to any posts around that. If you have to respond, say, I am not, it's inappropriate to post about an ongoing matter, period. Nothing else. So they know why you're there, but you're not doing it. All right. Can a governmental entity delete citizens' posts? Spoliation isn't just for citizens, it's for government who doesn't like what citizens are posting on the public website. The starting point to determine whether a social media post can be deleted is understanding what type of forum is created by that page. We're going to go through the different types of fora or forums. Whatever you want. The is not just limited to physical forms. The courts in the United States Supreme Court said the courts recognize 3 types of governmental forums. First, the traditional public forum. You're out on the street corner, you're standing in front of the city hall, blah, blah, blah. A government designated or limited public forum, a meeting, a committee meeting, a city council meeting, and the non-public forum, right? So let's talk about it. Traditional public forum is the streets. Designated public forum, yes, we want to hear from you in your comments here. You can leave them in writing or give them, or a non-public forum is where the government says, no, you cannot hold public communication like an airport or a jail or a unconfined or circumstance which is under police surveillance or things like that. But the courts haven't definitely said where social media is. But here's a notable case, whether or not putting things on social media should be considered a public forum or a violation of law. First of all, case law on social media is public speech. In this Hawaii Foundation, the city of Honolulu prepared a website and allowed people to post on it. Well, a lot of people posted stuff that were negative to the city of Honolulu. They weren't doing it right. They weren't doing it fast enough. They were wasting money, blah, blah, blah. And so what the city did is they just deleted those posts, and the people are going, no, you designated it as pace and you have to leave it up. And the court said, you're right. If you delete it, that's censorship. And in Quick City, Beach Grove, that's a Indiana case, police department banned 2 women for posting because they posted negative things about the city of Beach Grove. And the settlement resulted in the claims being able to post again, and a new rules on warning other posters before they ban posts. And then the Supreme Court weighed in 2017. This is Packingham versus North Carolina. Now, this is back when good old Justice Kennedy was on the bench, and he was always that swing vote. So a sex offender was banned from doing any social media posts, but he posted because he said, I got a speeding ticket. I wasn't speeding. And so I sent them the information where I was, and they made me come all the way into Durham for the hearing anyway. And then they dismissed it as soon as I got there. Well, that was my big waste of time. So we just kind of venting that they wasted a couple of hours of his time going down when they were intending to dismiss the ticket. But The Durham police were checking on social media posts by sex offenders, and they saw that post about the speeding ticket, said, aha, they brought him in and they prosecuted him and they convicted him for making a social media post. But, and the North Carolina Supreme Court upheld the ban on it. But the United States Supreme Court said, no, Facebook is tantamount to a public forum. The dicta. Now, Roberts then and Thomas and Alito, they wrote a separate opinion. They concurred the result that he shouldn't have gotten in criminal trouble for posting about what happened in this public forum. But they refused to say, well, the whole internet is not the same as a city park or a city street. So we're going to have to develop new law as it goes along. What about censoring terms on public websites? PETA, ethical treatment of animals, right, versus Texas A&M. Now, Texas A&M, which is just north of Houston, has one of the best veterinary schools, but PETA was alleging that they were, torturing these animals in their experiments and things like that. There were abuse and torture. And so they took down PETA's posts, and then PETA sued, and Texas saying it would prevent significant interference with university business. Ultimately, the case settled with a change to the Texas A&M University posting policy in favor of PETA. And now this is during his first term. What about at the real Donald Trump? Well, are his tweets a public forum because he's president? And in Knight versus First Amendment Institute at Columbia et al. Versus Donald Trump, they said, well, this is Twitter, and he started that Twitter account in 2009, but he did use it for political purposes. He identified himself as the president of the United States. He touted his legislative agenda. He defended his policies. So they said, well, yeah, you're using it as a political place. And so it was designated a public forum. Let's go on to number 5, ethical conduct involving jurors. Using social media research jurors. Ethics opinions say, yes, you can. And in fact, some things say you ought to if you have time. But both stress using caution so as not to inadvertently communicate with a juror. Sites like LinkedIn and Twitter inform them. I think LinkedIn still costs you $10 extra a month, but they'll tell you, hey, these people looked at your site. But if they're just looking at your site, it's still not impermissible communication. In the 2013 in the Hustle mortgage fraud trial, maybe that was the movie with Bradley Cooper and Amy Adams about, the banking mergers. Anyway, they complained about a first-year associate on the defense team peeking at his LinkedIn profile. Anyway, a subsequent ruling. We just, on April 2014, it's okay to review a juror's internet so long as no contact is initiated. And the fact that the juror finds out, as long as you don't go exceed the bounds of what that juror has purposely put up there for you to look at, it's fair game. You can look at it. All right. Danger area says forgetting the impact of what you share. Here, this is a picture by the Assistant District Attorney, Julie Jones, and the police officer. She's holding a shotgun and he's holding an assault rifle. And the post says, you should take the plea. The DA was not amused, saying Jones's contact was contrary to office protocol and with respect to handling of evidence. And see, these are just things we're learning to do along the way. Here's a fairly recent one that I found. As I was getting ready for this, I dug up some more for you. This is Judge Erica Ballou in Las Vegas. She posted a Facebook photo of herself in a hot tub with 2 of the public defenders who worked in their courtroom, one man and one woman. And referring to the male public defender, Ballou said he was surrounded by great, whatever that word was. It involved 2 T's and an S. At any rate, so her ethics charges were filed against her in January 2024. At the time I did this about a month ago, they still hadn't resolved. Okay, then of course you have these wonderful guys that encourage political violence. I'm hunting rhinos, which of course, are Republican in name only. And so it encourages violence. You're holding a gun saying, if I find you rhinos, I'll shoot you. That's not very good. Town judge shared his views. In Brunswick, New York, town judge Robert Schmidt in his Facebook page implies that Bill Clinton had Jeffrey Epstein killed, and he mocks gun control laws and compared Facebook censorship to Nazi book burning. Of course, somebody got to him and said, "You sound like an idiot." And so he groveled. He said, "I'm so sorry. So he just got admonished. You know, I think they ought to be a little harder on these people. And the risks of advocating for clients on social media. This happened, I think, right in Ellis County, which is the county right south of Dallas, Texas, where this guy was, trying a case, and he posts, "I was in the court yesterday cross-examining the witness who accused my innocent client. I got stuck for a second, was lost for the right. So I said a prayer. It was answered immediately. We got to the truth with this hostile witness. For those who say prayer won't work, you've never really played with the knowledge that it will be answered." Yeah, I guess that's all of us, because we really never know if it'll be answered. Roxanne Collins, the judge didn't like that. Anyway, and his Facebook prayers are met with gag orders from the Ellis County, Texas judges. Don't do that. So courtroom victory selfies in September 2015. Wisconsin ordered Anthony Cotton, there shown on the right, snaps a victory selfie with an acquitted murder client in the courtroom, then posts it on Facebook. And the judge didn't, quote, like it, and ordered Cotton to return to court to explain himself. Okay, zealous advocacy. If you ever just want to Google this case in the matter of James Hansen and see the vile thing that Mr. Hansen said, it reads like a script that, the guy who writes, family law would say. Indiana attorney sends his client's ex-husband a profanity-laced Facebook post where he says, "I'm going to gather all the relevant evidence, and I'm going to you so hard, your teeth are going to come loose. I've got you in my sights." And he was charged with felony intimidation. He really said a lot of really bad things. I'm surprised he only got a 30-day suspension from the practice of law, but that's a pretty funny case to read. Maybe not to Mr. Hansen. And now this is Joyce McCool. Joyce McCool is there's a technical name in I think in medicine for her. She's a nutball. And she was walking the court. She didn't even have a client. She was walking the courthouses, and she puts out all these inflammatory and misleading statements about cases in child custody case that had sealed information, and she's disbarred for her social media blitz. But she didn't even have a client in those cases. She was just a snoop. And she was posting stuff and made me think she was going to save the world or something. December 14, an Air Force lawyer posts comments on Facebook critical to the military's policy on sexual assault, resulting in criminal investigation of that lawyer. Now, the interesting thing on that case that I looked up, I'm going, what? She was actually complaining that male officers dating female enlisted personnel were treated quite differently than female officers dating enlisted personnel. It was really a two-tiered system, one that favored the males, and she was doing that. Well, she got criminally investigated. Other examples of lawyers behaving badly. In the matter of Gamble, that we talked about that. A suspension of a lawyer, egregious over the, she was the one who says, you D-bag, this was the other one. Yeah. Poses lawyer for egregious over-the-top messages on Facebook, unrepresented, unwed mother while representing the baby's biological father in an adoption proceeding. So he is saying, he's the lawyer, and he's saying terrible things. How dare you try to, give that baby away? You're a dirt ball, everything like that. So no, that's to the other side. Court held the lawyer of messages trying to make the mother feel guilty about consenting to give the child up for adoption constituted violations of Rule 8.4 and 8.4G, conduct reflecting adversely on that person's fitness to practice law. Here, tweeting from the courtroom, Chicago lawyer Vincent Schmeltz is at a spoofing trial. The spoofing is the high-frequency trading using algorithms, and he sends 9 tweets with pictures of the evidence, despite prominent courtroom signs saying photographs, recording, or broadcasting is prohibited right in front of them, and he's taking pictures of the evidence. He got a $5,000 fine in order to do 50 hours of pro bono work and order to attend a seminar in social media and legal ethics. Maybe Mr. Schmeltz is with us today. If you are, hello, Victor. All right, more examples of what not to do. Jason Morris, a Brooklyn assistant district attorney, has his Facebook page posted on a national media outlet. There he is in blackface. He's this tall white guy in blackface holding a Confederate flag and simulating prison rape. The Brooklyn DA isn't amused by the abhorrent, stupid, and childish behavior. And of course, in 2011, Indiana Deputy AG is fired after tweeting about using live ammo on pro-labor protesters in Madison, Wisconsin. And I like the second case here. We're going to talk about it for a second. Wayne, Michigan prosecutor Tina Walsh is fired after suggesting on Facebook that rioters should be shot. And AUSA, a distinct U.S. Attorney John Kraft in Beaumont, that's in Eastern Texas, comes under fire for inflammatory posts on Facebook about the Trayvon Martin case and derogatory statements about President Obama, including referring to him as the Dalai Lama. And the U.S. Attorney for the Eastern District, John Bales, calls the comments reprehensible. So defense attorneys then, of course, use those comments to say, I want a new trial. This guy's sentencing recommendations were all off, and it's because he's a racist. So then, of course, you do us a favor. Here's these. Florida prosecutor Kenneth Lewis posts controversial comments after the Orlando nightclub mass shooting. I can't believe it's 7 years ago. Says nightclubs are utter cesspools of debauchery and Orlando should be leveled as a melting pot of third world miscreants and ghetto thugs. And he lost his job, as he probably should. And then, of course, what we talked about before, this Salvatore Perrocana, in New Orleans, there's 2,600 comments with 5 identities, 1 to 200 posts related to the matters being handled by his office, and he is barred because his actions betrayed and caused actual harm to pending prosecutions. What about online reviews? Do not ask your client to post reviews. Everybody does it, and it's not unethical anymore in most states. But I always say your good review is the fact you got paid. It's a confidential communication. If you're going to ask your client to post on what a great lawyer you were, make sure you tell that client, you don't have to do this because I'm asking you to breach the attorney-client privilege that you have a right to expect from me if you're going to post for me. So you don't have to do that unless you want to, because there's a lot of lawyers, there's a lot of clients out there that I'm sure, I just talked to one today, would never want anybody to know that he even had to have a lawyer, high up a politician. And so if I say, oh yeah, why don't you tell everybody how great I was in your criminal case? No, I don't like that. What about, I say, good clients pay you. Consider that your good review. And once you start soliciting reviews, you encourage those displeased with your wife to post negative reviews. As I always say, maybe you think this is too, but you know who knows how to post? Crazy people. They'll post all day long. They don't care what they don't pay any attention to that, injunction you got against them further saying anything, because they got nothing to lose. They got nothing, and they're going to make it even because, by the way, you were the third lawyer that couldn't do their unreasonable demands. So watch it. Once you start doing that, doctors, I got a few doctors here who lost their license. Dr. Catherine Grawa, Dr. Roxley lost her medical license for harming patients while live streaming their surgery. She's doing surgery and talking, and then she harmed a patient during social media. Dr. Jason Campbell, the TikTok doc, gained fame first by dancing on camera, but then it was said, wait a minute, that's the guy who's guilty of sexual harassment. He ended up paying $585,000. Dr. Kololab was a Cleveland clinic resident, career ended for anti-Semitic tweets from years ago, served Internet's written in ink. And Dr. Dalia Carese, Sydney, Australia, pretended to be a doctor online and gave advice to over 100,000. She had to plead guilty to that. All right. Finally, here's a funny case. It comes out of North Texas. This is north of Dallas. This Van Dyke says, I'm a lawyer and I'll show you, Mr. Retzlaff. Attorney Van Dyke sues his online critic, Retzlaff, who had referred to Van Dyke as a Nazi and a white supremacist. He sues in the Eastern District of Texas, and they both exchange bitter emails and messages. And then finally prompting Van Dyke to declare in his December 2nd message, this guy's cost me damn near 2 full years of my life, and I'm not going to spend another minute of my time in the FBI, and the courts and state bar can do what they want. Because frankly, I do not give a solitary, I think it was fish is the word he was looking for. Said, I'm out, and as far as I'm concerned, Thomas Retzlaff no longer exists, which just plays into Retzlaff's hands. And he says, my position is this: Van Dyke can go fish for himself. I ain't dismissing shots. If he wants to quit, fine, but I'm winning. So fish him. All right. The danger of engaging. So then Van Dyke files a motion for court order dismissal, and he basically says the plaintiff was dismissed this lawsuit. He is of the opinion that short of the locking defendant in a prison cell for the rest of his life, there is nothing that any other court can do to stop defendant from continuing harassment, and there's no resolution of this case that will stop defendant's behavior. And the defendant has already placed plaintiff in dire financial straits. Simply put, plaintiff lacks the time and resources to continue litigating. See, that's what you had when you poke the bear. You sometimes get bit. And revealing confidences isn't helpful. When your client says a bad thing about you, you can't say, yeah, well, he was a dirtbag and he's a liar and everything like that. The best thing I've ever seen was that the paragraph you see at the very bottom. That was the Pennsylvania Bar Association formal ethics opinion that says, a lawyer, when you're getting bad review, a lawyer's duty to keep client confidences has a few exceptions and an abundance of caution. I do not feel at liberty to respond in a point-by-point fashion in this form. Suffice to say that I do not believe the post prepares a fair and accurate picture of the events. Now, I gave this to a friend of mine who was a plaintiff's attorney, and the woman was complaining he didn't get enough money. And the other thing he added on this, which I thought was brilliant because it made him look, said, we have invited Mrs. Jones to come to our office and review her file with us. And we've been glad to do that, no cost to her. And so far she has refused to come. All right, that shows, look, we're being good guys. She's the dirtbag here. Anyway, so practice caveats for you. Refrain from posting during trials. Refrain from any commentary about your clients, period. Remain the adult. You have fiduciary duties. The essence of this profession is confidentiality and discretion. You're going to be judged by your worst post. Remember the woman who posted, she was in a big advertising firm in New York, and she was on her first trip to Cape Town, South Africa, and she posted, gosh, this is already about 7 or 8 years ago, said, hey, I'm getting to go to Africa. Ooh, hope I don't get AIDS. Don't worry, I'm white. And by the time she arrived there, she had been fired from her job. And of course, her tweets led a million people to say the most vile things about her. So the punishment for being a bad tweet is like 10 times worse than what you ever intended to do. So you're going to be judged by your worst post. Don't ask for online interviews. Never tweet or post anything you wouldn't say to a person's face. So again, review your client's social media, if at all, before signing on, because you might be in a big problem. Every post is permanent. You'll be judged by your worst. Legal representation tells a willingness to refrain from posting and never reveal anything, strategies, evidence, attitudes, or opinions. Never post or tweet anything you wouldn't say to the person's face, and don't try to destroy or permanently delete evidence. And if you can't say it to their face, you're probably using it wrong, right? You rarely need to use it. You're a trusted confidant. If you do tell the truth, if the truth will get you in trouble, you're likely using it inappropriately. And before posting social media, consider every single negative connotation, and do not ask clients to post anything about you. Now, I will end with this. I have just a couple of minutes left. I strongly believe this to the core of my existence. We are the most important profession in the United States of America. We are that guardians of the rule of law. That is our social compact to handle disputes with laws and within rules. And if the rules aren't good enough, we'll make better rules, but we'll always do that. And part of that is our duty of civility. Our civility means we are going to create a safe space to hear and consider and have people who can do something about it. All opinions. That doesn't mean our opinions are always right, but the opinions we have might be influenced on some of the opinions of others, even if they're not right. So we need, the whole point of the rule of law is for us to listen and create a space where we can exchange opinions. And you have something wonderful in your pocket, and that's a law license. You can reduce people's suffering. You can solve their problems. You can remove their strength. You can make their lives better. And we need to use that, and always remember how gifted we are that we have that access in this society at this moment in time. We are here to support the fair administration of justice. So there you have it. There you have my email, Claude@lawpay.com. I'm delighted to have been invited today. I've got many more presentations that I'm happy to present to the Beverly Hills Bar Association. And I'm thinking of you out there right now as I'm sitting in Austin, Texas, and thinking about my very, very happy childhood growing up there in California. And so I'm going to turn it back over and see if any questions. If not, I'll let you all go. Are you there, Jose?
Yes, I am. And we do, if you click on the Q&A, you will see the questions.
All right, let me see if I can find that.
You might want to stop your screen share.
Okay, here we go. Hi, everybody. So, okay, I had Beverly Hills questions. Yeah, Claude, LawPay. Let's see. Did you say there's more questions?
Yeah, there's if you click on the Q&A, we have
okay. I'm sorry.
No worries.
All right. Thank you very much. Please share your social media clauses used for engagement. Absolutely. I will send that to the Beverly Hills Bar, or you can send me if you want. Again, Claude at LawPay, and I'll send it to you immediately. I'll send you a whole packet. It's part of the reluctance to categorize Facebook and social media as private forums due to the First Amendment implications. Yes. The courts found social media, would that prevent Facebook private? Well, this is a longer thing that I'll have time to do. Is there a line between posts made in the course of business and an attorney's private speech when not on the clock, or a lawyer's just not able to engage in offensive speech generally? Boy, I wish I could answer that question. You ask great questions. I think that the wiser thing is to avoid offensive speech. Now, clearly, I'm not, immune to that either. There's times that I've been, wish I hadn't said things because it's hard to take them back. But let's see if there's a couple of other things, Donna. Thank you very much. I hope it's okay for me to say that I love Claude. Oh, well, thank you, Donna. And again, there are so many presentations that I have that you would love, like how to prepare witnesses. Some of that I do on contract construction are people's favorite on how to improve your contracts. Because anyway, thank you very much, Judge Pawzek. Thank you very much, Kathleen, all of you. Thank you very much. I know you're probably willing to get back into your day and get back to work. And you all have a wonderful holiday season. And I'm told by all of my wonderful Jewish friends that we have this really unusual thing where both Christmas and the first day of Hanukkah on the great day. So everyone, please enjoy it and try to get a little rest too and do something you really want to do. Thanks, everyone.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.